politicians, both at the national level and at the state level. So I think you're all to be commended for your wonderful work. I am a native of Utah. I was born in Kanab and was raised mostly raised for much of my life, my early life in the Rose Park area here in Salt Lake City, and then went to Brigham Young University as an undergraduate, and then went away to law school, and kind of became enamored with the idea that you could have a lawn that grows that you don't have to water. And so my wife and I elected to stay out on the East Coast with what became a very large family. We have 7 children. But I now fortunately have a foot back in Utah regularly, in that I'm an adjunct professor at BYU Law School, where I teach courses on constitutional law and U.S. Supreme Court advocacy. So I very much appreciate my continued close contacts with the state of Utah. Now, I've been asked to share some thoughts about the legal case involving SB 54, which I'm honored to be able to work on your behalf. Now, at first blush, and you all are familiar, I'm sure, with that lawsuit and with the underlying legislation that's being challenged there. At first blush, when you look at that lawsuit, people may be tempted to think that that lawsuit is all about the choice between the caucus convention system on the one hand and the petition system on the other, as a way of nominating candidates. And of course, the immediate holding in the unfortunate opinion from the 10th Circuit was to uphold SB 54 and thereby to force the party to accept a petition process as one route to a nomination. But as the Chief Judge's dissent in that case points out, the central issue in that lawsuit is really much deeper than the choice of how do we get nominees on the ballot. The central issue is really about the scope of the government's power to regulate core functions and even messages of a political party, or indeed any voluntary expressive association, under the First Amendment. And so the underlying issue is really a First Amendment issue. And in that regard, I appreciated the prayer that was given earlier that mentioned the First Amendment and its protections. But that's really what's at stake, is the scope of the First Amendment's protection, not only for political parties, but for all kinds of voluntary associations. And that could include anything from the Boy Scouts to the neighborhood swim club, maybe, or to even churches. And so the issues are very important. And in the course of upholding SB 54, the 10th Circuit majority made 2 critical First Amendment holdings that we've challenged in a petition for rehearing by the full court. All 12 members of the 10th Circuit, we've asked them to take a second look at the majority opinion. And at the risk of being overly technical, let me just review for you what those 2 issues are. The first is, or the first holding that was made by the majority that we're challenging, was the holding that government's regulation of a party's mechanism for choosing candidates does not violate the First Amendment, even when the evidence shows that the purpose of the regulation was to influence the chosen candidate's substantive views and therefore the message of the party. The second holding was a more general holding about how we resolve First Amendment questions in lawsuits, and what the majority hold, and we've also challenged this, is that in determining the First Amendment impact of a regulation on a party, or by extension any expressive association, courts should examine the burden from the standpoint of the rank and file members, not from the standpoint of the institution as constituted by its internal regulations and bylaws. And we've had a lot of discussion in this meeting about the importance of the party's constitution and bylaws. And so we all in this room, we understand how important those things are, and yet the 10th Circuit majority sort of threw all that aside and said, no, we're going to look at the impact of this government regulation based on our own speculation about how party rank and file members in general would feel about it. consider for a moment then the implications of that idea. If a court can ignore the views of a political party's duly constituted leadership in determining the impact of a government regulation in favor of their own speculation on the views of the party's rank and file, what's to keep a court from taking that same approach in determining the impact of even more burdensome regulations on other expressive associations like churches and service clubs? Imagine, for example, a federal law that said, that all churches have to select for leadership positions and for ordination men and women on the same terms as each other, right? So that would obviously be a direct affront, for example, to the Catholic faith, which limits its priesthood to women. Or suppose there's a federal law that says all churches have to recognize same-sex marriages and opposite-sex marriages on the same terms, right? Just imagine a law like that. And so the majority's approach would say, well, we're not going to really look at what the hierarchy in those organizations say, or what the Constitution and bylaws, or even the scriptures say about the issue. We're going to look at it from the standpoint of ordinary members. And in the case of ordaining women, the court might say, well, we know first of all that at least half of Catholics are women, and so we don't think they're going to mind if women are ordained to the priesthood. And and we look at opinion polls of what ordinary Catholics think about that issue, and we think a clear majority of Catholics believe that it would be just fine to ordain women, and so they would conclude there's no First Amendment burden on the Catholic Church by a regulation or a law that forces them to ordain women to the priesthood. So it's a very sweeping, in my view, really a broadside attack on some important First Amendment principles to undertake the analysis that way. So for that and other reasons, I believe this case is a very important effort to vindicate the First Amendment rights, as I said earlier, not just of the Utah Republican Party, but of all expressive associations throughout the state and throughout the 10th Circuit. And of course, the 10th Circuit includes the states of Colorado and New Mexico and Arkansas and Oklahoma and others. So it's a big chunk of the country where, in my view, First Amendment rights are under attack by this majority opinion. Let me just say a word about the process for the case going forward. We have already, as you know, filed a petition for rehearing, or in the alternative for rehearing en banc. That means if the panel doesn't grant us relief, and I don't suspect they will, then we're asking the entire court, all 12 active members of the court, to reverse the panel. So we filed that petition on April 18th, and the court then ordered the state to file a response, which is relatively unusual, and indicated that there's some interest within the 10th Circuit in our petition, and then the state filed its response on May 15th. And ironically, the state's response actually suggests that the party nomination process is really the state's own process, suggesting that the party itself is in some sense an arm of the state rather than a truly private organization. And when you look at it, to me, that seems like the underlying mistake in the majority's opinion, and to some extent the underlying mistake in the views of those who have been pressing this issue for a long time, is they tend to view the party as, in a sense, an arm of the state rather than the truly private, voluntary organization that it is. So we'll be filing a reply in support of our petition next week by May 23rd. Now, if the 10th Circuit grants rehearing en banc, that'll be wonderful. They will probably have re-argument in the case before all 12 active judges. Again, if they grant our petition. If they don't grant the petition, we are hoping that there will be a vigorous dissent from not just Judge Temkovich, who was the dissenter, but also from other members of the 10th Circuit, who will basically, we hope, tell the U.S. Supreme Court, we think you ought to take this case, and we think you ought to clear this mess up. Because to some extent, the problem in the litigation is that there's some ambiguity in prior Supreme Court decisions There's language in prior court decisions that the majority was able to seize on. I think they misinterpreted it, but they were able to seize on some language from prior Supreme Court decisions to justify their results. So hopefully, at a minimum, we will get a very strong statement from not just one, but a number of 10th Circuit judges telling the Supreme Court, you ought to take this case and decide this issue on a nationwide basis. So if the 10th Circuit denies rehearing, just as a procedural matter, we'll have 90 days to file what's known as a petition for a writ of certiorari, which is a petition that basically asks the Supreme Court to take this case over and decide it themselves. And it will then take anywhere from 2 to 4 months for the Supreme Court to decide whether to take the case. And if they agree, if they grant our petition and agree to hear the case on the merits, it will then take anywhere from 6 to 12 more months for the court to conclusively resolve the case. So that's the process in a nutshell, and I'm happy to take questions from those who have questions.